Welcome back to Law Explained America. I'm Daniel Carter. Tonight's discussion may be one of the most important conversations you will hear this year. If you own a home, have money in a checking account, maintain a retirement fund, or simply want to make sure that the people you love are protected after you're gone, then stay with me until the very end of this video, because what I'm about to reveal isn't a theory, and it's not fear-mongering. These are real legal mechanisms that exist right now in the United States, and every year they cost American families millions of dollars. The shocking part is that most people never realize these dangers exist until they are standing in a bank, sitting in a lawyer's office, or receiving a letter from the government after a loved one has passed away. By then, it's already too late. Tonight, we're exposing the 5 biggest legal traps that can quietly destroy the wealth you've spent your entire life building. More importantly, I'm going to show you exactly how to avoid them using simple legal tools that many people have never even heard of. Before we begin, take a second to subscribe to Law Explained America and turn on the notification bell. This channel exists for one reason: to help everyday Americans understand the laws that affect their money, their property, and their families. Because legal knowledge isn't just information, sometimes it's financial survival. And tonight, what you learn could protect your family for generations. Let's begin with the first legal trap. It affects almost every person watching this video: your bank account. Most Americans believe that when they pass away, the money sitting in their checking or savings account automatically goes to their spouse or children. Legally, that assumption can be completely wrong. If your bank account does not have a beneficiary listed on it, the money doesn't immediately pass to your family. Instead, it becomes part of your estate, and the moment that happens, something called probate begins. You've probably heard the word probate before, but most people don't understand how serious this process can be. Probate is a court-supervised legal procedure used to distribute a deceased person's assets. Once your money enters probate, your family loses immediate access to it. Many people believe that having a will solves this problem. Unfortunately, that's not how the law works. A will is essentially a set of instructions for the probate court. At the bank counter, your will has no immediate authority. The bank is legally required to follow the contract you signed when you opened the account. If that contract doesn't contain a beneficiary designation, the bank cannot simply hand your money over to your spouse, your children, or anyone else. Even if everyone agrees on who should receive it, even if your will clearly names your heirs, the bank's answer is still the same: the account must go through probate. Now, let's talk about what probate actually looks like in the real world. In many states, probate law requires a waiting period, so creditors have time to come forward and make claims against the estate. This waiting period often lasts between 3 and 6 months. During that time, your family may not receive a single dollar. Meanwhile, life keeps moving. Mortgage payments still need to be made. Property taxes still come due. Utility bills continue. Funeral expenses arrive. Medical bills arrive, and your family may suddenly find themselves struggling financially while your money sits frozen in a legal process. Then come the costs: court filing fees, publication fees, executor expenses, and attorney fees. In some states, probate attorneys are paid based on a percentage of the gross value of the estate. That means even a modest estate can end up paying thousands of dollars in legal costs. $10,000, $15,000, sometimes much more. And if family members disagree or the estate becomes complicated, probate can continue for 1 or even 2 years. Fortunately, there is an incredibly simple solution. It's called a Payable-On-Death designation, often referred to as a POD. Every major bank in America offers this option. You simply contact your bank, request the beneficiary designation form, and name the person you want to inherit the account. When you pass away, your beneficiary provides a death certificate, the bank verifies the information, and the money can often be transferred within days. No probate, no court hearings, no waiting periods, no expensive legal process. There are 3 things you absolutely need to know. First, every account requires its own beneficiary form. Your checking account, your savings account, and your certificates of deposit are all separate legal contracts. Filling out one form does not automatically protect your other accounts. Second, brokerage accounts usually use a different form called a Transfer on Death designation, or TOD. If you own stocks, mutual funds, or investment accounts, and no TOD is listed, those assets can still end up in probate. Third, always name a backup beneficiary, because if your primary beneficiary passes away before you and no contingent beneficiary is listed, the account may still become part of your estate. Now let's move to the second legal trap, and for millions of Americans, this one involves their largest asset, their home. For many families, a house isn't just a piece of property, it's a lifetime of work, a place where children were raised, and often the most valuable asset a person owns. But if your home is titled only in your name and you haven't created a legal transfer mechanism, your house may also be forced through probate after your death. The consequences can be devastating. The home becomes legally frozen, your family cannot sell it, refinance it, or access the equity. In many cases, they cannot make major decisions regarding the property until the probate court gives them legal authority. That process may take 6 months, a year, or even longer. But while your family waits, the bills don't stop. The mortgage still has to be paid. Property taxes continue. Insurance premiums continue. Repairs continue. Maintenance continues. One option to avoid this problem is called joint tenancy with right of survivorship. Under this arrangement, if one owner dies, the surviving owner automatically becomes the sole owner of the property. But there can be risks because adding someone to your deed means they become a legal owner immediately. If that person gets divorced, has financial problems, or is sued by creditors, your property could potentially become involved in those issues. For many families, there is another option that may work even better. It's called a transfer-on-death deed. A transfer-on-death deed allows you to name a beneficiary for your home. While you're alive, the beneficiary has no ownership rights. But after your death, the property can transfer directly to the beneficiary simply by recording a death certificate with the county. No probate, no expensive court process, no lengthy delays. Now let's talk about the third legal trap, Medicaid estate recovery. This isn't about banks or private companies. This involves the government itself. Federal law requires every state to operate something called a Medicaid estate recovery program. Under these laws, after a person dies, the state can attempt to recover the money it spent on certain Medicaid benefits. In many cases, the largest asset targeted during this process is the family home. A parent spends years in a nursing home. Medicaid helps cover the costs. The parent eventually passes away. Then the children receive an official letter from the state stating that Medicaid spent hundreds of thousands of dollars on the parent's care and now seeks reimbursement from the estate. Nursing home care in the United States has become incredibly expensive. In many parts of the country, long-term care can cost well over $100,000 per year. A 2-year stay can easily generate expenses of $200,000. A 3-year stay can create claims exceeding $300,000. There are important protections. If a surviving spouse is still living in the home, recovery is generally delayed. If a blind or disabled child lives there, certain protections may apply. There is also something called the caregiver child exception, but the critical issue is timing. Federal law contains something called the 5-year look-back period. If you give away assets within 5 years of applying for Medicaid, you may face a penalty period during which Medicaid can refuse to pay for your care. That's why proper planning needs to happen years in advance. One of the most common legal tools used in this area is called an irrevocable Medicaid Asset Protection Trust. The rules surrounding these trusts are complicated and vary from state to state, which is why many elder law attorneys recommend speaking with a professional long before long-term care becomes necessary. Now let's move to our fourth legal trap, outdated beneficiary designations on retirement accounts. Your IRA, your 401k, your pension, and your 403b usually pass directly to the person named on the beneficiary form. They don't normally go through probate. That sounds like a good thing until the wrong person is listed. Let's say you opened an IRA 20 years ago and named your spouse as beneficiary. Years later, you divorced and remarried, but you forgot to update the beneficiary form. When you pass away, many people assume the current spouse receives the money. In reality, the ex-spouse may receive everything because the beneficiary designation on file often controls. This has happened countless times across America. Entire estates have lost hundreds of thousands of dollars because one old beneficiary form remained unchanged. Retirement accounts represent the largest financial asset for many families. One outdated form can redirect an entire life savings. That's why every adult should log into every retirement account they own and ask one question. If I died tonight, is this the person I actually want to receive this money? If the answer is no, update it immediately. Finally, let's talk about the fifth legal trap, a safe deposit box. Millions of Americans believe that giving someone a spare key means that person will automatically have access after their death. Unfortunately, that's often not true. The moment a bank is officially notified that a customer has died, access to the safe deposit box may become restricted. Imagine a father keeps his original will inside his safe deposit box. He passes away unexpectedly. The family knows the will is inside the box, but they cannot access it. At the same time, the court wants to see the original will before moving forward with probate procedures. Suddenly, the family is trapped in a frustrating legal situation. Some families spend weeks trying to recover documents they thought would be immediately available. Others cannot locate property deeds, insurance information, or financial records because everything is locked away. One simple solution is to consider adding a trusted person as a joint renter on the safe deposit box agreement. Another option is to avoid storing certain critical documents inside the box altogether. Now let's put everything together. Review every bank account you own and make sure each one has a payable-on-death designation. Review your brokerage and investment accounts and make sure transfer-on-death forms are in place. Review how your home is titled and determine whether a transfer-on-death deed may be appropriate. If you or your spouse may someday need long-term care, begin learning about Medicaid planning before the 5-year look-back period becomes a crisis. Examine every retirement account you own and verify your beneficiaries. Finally, review the contents of your safe deposit box and make sure your loved ones can access the documents they may need. Here's the truth. Most financial disasters that occur after someone's death aren't caused by greed or complicated legal tricks. They're caused by ordinary people simply not knowing how the system works. The law doesn't care what you intended. The law cares about documents. The law cares about ownership. The law cares about forms that were signed or forms that were never signed. That's why planning matters, because protecting your family isn't just about earning money. It's about making sure that money reaches the people you love when they need it most. If this report helped you, subscribe to Law Explained America and turn on the notification bell so you never miss future legal updates that could affect your finances, your property, and your family's future. I'm Daniel Carter. Thank you for watching Law Explained America. Stay informed, stay prepared, and as always, know your rights before it's too late.